Good afternoon. This is John Rhodes, the Chair of the Board on Electric Generation Siting and the Environment. And I'd like to call this meeting of the Board on Electric Generation Siting and the Environment to order. Before we get started, I would like to note our arrangements for the meeting today. In line with the guidelines concerning social distancing and minimizing large gatherings, and in keeping with executive orders suspending provisions of the Open Meetings Law on an emergency basis, we are conducting today's meeting remotely. I'd like to remind those who are participating by phone to please mute your lines, except when you are speaking. The public will have the opportunity to listen to the meeting by going to the department's webcast page, and we will also record and transcribe the meeting as has been our practice. These arrangements have been reviewed by our General Counsel, and he has found that they meet the requirements of the executive orders and that they meet my own expectations of honoring the intent of the Open Meetings Law. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. And for good order's sake, when I introduce you, could you please acknowledge your presence, yes, or present, or some other statement like that. Louis Alexander, alternate of Basil Sagos, Department of Environmental Conservation.
Present.
Thank you. Dr. Elizabeth Lewis Michael, alternate of Dr. Howard Zucker, Department of Health.
Present.
Thank you. Vincent Ravishir, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development and President and Chief Executive Officer Designate, Empire State Development.
Present.
Thank you. And John Williams, alternate to Richard Kaufman, New York State Energy Research and Development Authority.
Present.
Thank you. And I would like to introduce the ad hoc member of the Mohawk Solar Article 10 Siting Board, Greg Iacobucci.
Present.
Thank you very much. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. In which case, we'll get right into it. We have case 19F0182, application of Mohawk Solar LLC for a certificate of environmental compatibility and public need pursuant to Article 10 of the Public Service Law for construction of a solar electric generating facility in the towns of Canajoharie and Minden, Montgomery County, presented by Erica Burden, Administrative Law Judge, Department of Public Service, and by James McClymans, Chief Administrative Law Judge, Department of Environmental Conservation. Also available to answer questions are Sean Mullaney, Administrative Law Judge, Department of Public Service, Molly McBride, Administrative Law Judge, Department of Environmental Conservation, Dakin LaCakes, Chief Administrative Law Judge, Department of Public Service, and Robert Rosenthal, General Counsel, Department of Public Service and of the Siting Board. Judge Bergen and Judge McClymans, please begin.
Thank you. Good afternoon, Chair Rhodes and members of the Siting Board. My name is Erica Bergen, and I co-presided over this case with examiners Sean Mullaney of the Department of Public Service and Molly McBride of the Department of Environmental Conservation. I will provide an overview of the item before you, which is a proposed order of the Siting Board granting a certificate of environmental compatibility and public need to Mohawk Solar LLC, subject to certain terms and conditions. James McClymans, Chief Administrative Law Judge of the Department of Environmental Conservation, also will offer brief remarks on the disputed issues that were in this case. Mohawk Solar, a wholly owned subsidiary of Avangrid Renewables, proposes to construct and operate a commercial-scale solar electric generating facility within the towns of Canajoharie and Minden in Montgomery County. The project is a large-scale renewable energy facility consisting of up to 529 acres of photovoltaic solar panels and related facilities. The facility will generate up to 90.5 megawatts of electricity, which is enough to meet the average annual demand of more than 28,000 New York homes. The grant of a certificate to Mohawk Solar would be subject to the conditions that are attached to the proposed order. The proposed order is supported by a robust and extensive evidentiary record that supports all the statutory findings that the Siting Board must make before issuing a certificate pursuant to Article 10 of the Public Service Law. The Article 10 review process in this case was extensive, fair, and open, and included both pre-application and post-application phases. Notice to the public was provided with respect to all significant milestones in the case. There were many instances of community outreach and education and numerous opportunities for public participation. Mohawk Solar carried out a public involvement program, which included, among other things, establishing a project-specific website, a local document repository, a toll-free telephone number for access to project information. In addition, throughout the Article 10 process, the Department of Public Service engaged in extensive public outreach and sent notice of all significant project milestones to the party and service list. The department also hosted a local public statement hearing in the town of Canajoharie in January 2020 and solicited public comments through multiple other means. Aside from the state agency parties in this case, the towns of Canajoharie and Minden were the only active parties, and they were jointly represented by council. Intervenor funding was awarded jointly to these towns at both the pre-application and the application phases. The towns were awarded a total of $31,500 in the pre-application phase and $90,500 in application funding. The department received 14 public comments in this case on DMM and at the public statement hearing. Most comments were submitted by residents, and most commenters support the project, citing the benefits of renewable energy and the harms posed by global warming. Other benefits cited include local economic benefits because of jobs and revenue the project will provide to leaseholders, local municipalities, and school districts. Opponents to the project cited concerns about how much energy the project would provide to the local community, if any, visual impacts, loss of agricultural land, impacts to wildlife, including threatened and endangered grassland bird species, and the cumulative adverse impacts of this and other similar projects proposed in the surrounding areas. The proposed certificate conditions attached to the proposed order before you address the identified environmental impacts of the project, including impacts that have been the subject of public concern. Most of the proposed conditions, which are based on conditions proposed in a supplemental settlement proposal negotiated by the parties, were undisputed or are the result of those settlement negotiations. The parties' supplemental settlement proposal, however, left two areas of dispute for resolution by the board: a dispute between the applicant, Mohawk Solar, and DEC staff regarding the project's compliance with the State Endangered Species Act, and a dispute between the applicant and the Department of Agriculture and Market staff regarding the project's impacts to prime agricultural farmland. Judge McClymans will now brief the board on these disputed issues and the resolution of those issues in the proposed order. Judge McClymans?
Thank you, Judge Bergen, and thank you, Chairman Rhodes and members of the Siting Board for the opportunity to speak with you this afternoon. As just mentioned, as a result of settlement negotiations culminating in the parties' supplemental settlement proposal, the only issues remaining in dispute between the applicant and DEC staff concern two proposed certificate conditions related to threatened or endangered, or T&E, grassland bird species, and one condition related to T&E bird species in general. In addition, a dispute remains between the applicant and agricultural market staff concerning the impact of the applicant's grassland bird net conservation benefit plan, or NCPB, on agricultural lands. With respect to T&E grassland bird species, the first dispute between the applicant and DEC staff concerns Certificate Condition 83C, which contains an exception from a daily monitoring requirement for construction in the occupied habitat of T&E grassland bird species during the breeding season from April 23 to August 15 in fields that have a history of use for row crops. In briefing, the applicant requests that if fields were planted with row crops in the last 2 farming seasons prior to the commencement of construction, and those fields were also historically planted with row crops during at least one of the prior 6 years, those fields would not be subject to a breeding season construction prohibition or the daily survey requirement. The draft order concludes that the applicant's requested condition may be accepted based upon record evidence that row crops are not the preferred habitat of teeny grassland bird species, and the certificate conditions that would apply in the event teeny grassland birds are in fact encountered during construction. The second dispute between the applicant and DEC staff concerns the size of the protective buffer area, or the area in which construction activities must cease unless authorized to resume, to be employed in the event T&E grassland bird species are detected during construction in occupied habitat in either the breeding or the wintering seasons. The applicant requested that the standard 500-foot buffer be employed, not a 200-meter or approximately 660-foot buffer, as requested by DEC. The draft order concludes that the standard 500-foot buffer, in combination with the daily survey by the environmental monitor, is sufficient to avoid the direct take of teeny grassland bird species and accordingly adopts the buffer proposed by the applicant. The final issues between the applicant and DEC staff concern applicant's proposed changes to Certificate Condition 85, which governs the discovery of nests or roosts of teeny birds generally, including bald eagles, during project construction or operation. The draft order grants the applicant's request that Condition 85 only apply to the discovery of active nests or roosts on the ground that the on-site environmental monitor may make the initial determination whether a nest or roost is active, provided the monitor applies a generally accepted scientific standards for identifying active nests or roosts. The draft order otherwise rejects the other changes requested by the applicant on the ground that the changes relate to standard conditions from which the applicant has not justified any departure. Accordingly, the draft order concludes that based upon the above conditions and agreed upon conditions and the site engineering environmental plan guidelines related to teeny bird species, the project will be constructed and operated in compliance with the State Endangered Species Act. The final disputed issues concern the Department of Agriculture and Markets' objection to the use of off-site prime farmland, or farmland containing priority soils groups 1 through 4, for the grassland bird mitigation plan laid out in the applicant's revised Net Conservation Benefit Plan. The draft order concludes that the appropriate standard to resolve Ag and Markets' objection is the Article 10 standard, namely, that the applicant must demonstrate that impacts to agricultural resources would be avoided, minimized, and mitigated to the maximum extent practicable. However, because the Net Conservation Benefit Plan has not been finalized and the final mitigation lands have not yet been selected, the draft order concludes it is premature to determine whether the Article 10 standard has been met. Instead, the determination whether the plan meets the Article 10 standard will take place during the compliance phase of the project. Thank you again for the opportunity to brief you on the proposed order. I remain available for any questions you may have, and I return it to you, Judge Bergen.
Thank you, Judge McClyman. Based upon the foregoing, the record supports a finding by the board that the probable environmental impacts of the construction and operation of the facility will be minimized or avoided to the maximum extent practicable, provided that the applicant complies with the certificate conditions. The record also supports a finding by the board that the facility is designed to operate in compliance with all applicable state and local environmental, health, and safety law and regulations. The proposed order, if adopted, would find that the construction and operation of the project will serve the public interest because the project will be consistent with state energy policies, long-range energy planning objectives, the strategies set forth in the most recent state energy plan, and the additional social, economic, and other factors deemed relevant by the board. The examiners recommend that the board adopt the proposed order, including the attached certificate conditions. Thank you.
This is John Rhodes. Thank you very much. Judges McClymans and Bergen. That was a very nice presentation of a solid and persuasive record. I'm pleased that only a few, namely two issues, could not be resolved by discussions between the parties. And I'm also pleased that the two disputes that you make a point of pointing out were able to be resolved with what, in my mind, to my eyes, is a reasoned resolution of the issues, record-based, and paying all appropriate attention and meeting the standard of minimizing or avoiding to the maximum extent practical the probable environmental impacts, and otherwise finding that under these conditions, the project will be in the public interest. So I have no questions, and I will be inclined to vote in favor of the item. At this point, I now go down and effectively roll call my colleagues on the siting board and ask them if they have any comments or questions. Mr. Alexander.
Thank you, Chair Rhodes. I also would like to thank the examiners for their review of the matter before us today. And I would also like to commend the parties for their efforts and success in settling many of the matters at issue in this proceeding. As discussed in this order and as set forth in the Public Service Law, this siting board may not grant a certificate unless various determinations can be made. And in that regard, a number of factors are considered, as noted on page 11 of this order, including but not limited to environmental impacts. The process is reflected in the examiner's presentation today, underscores a careful evaluation of the merits of this case. It is clear, however, that the balancing of the factors that must be considered can lead to hard and difficult choices at times. There are some aspects in this proceeding, both procedural and substantive, that I wish to comment on. I shall keep my comments brief. First, procedurally, this is the first Article 10 proceeding which has reached this siting board that did not have a recommended decision. I understand that a recommended decision in various circumstances has not always been considered necessary. I think that a recommended decision, which provides the examiners an opportunity to address and evaluate matters at issue, can be, where appropriate, a useful component to the process. A recommended decision can be beneficial, particularly where disputes arise on environmental matters, and I would suggest that in future proceedings, the preparation of a recommended decision be given consideration where these types of matters are at issue. Second, I have some comments that relate to the parties' presentations in testimony and in their briefing. The first is to the issue regarding the meaning of active nest, which is addressed in this order. The order, as discussed by the examiners, incorporates the adjective active and states that the determination of what is an active nest must be made based on generally accepted scientific indicia. Now, the various indicia are set forth in the order, including a reference to a U.S. Fish and Wildlife Service publication of which official notice is being taken. I would encourage parties in Article 10 proceedings to be as thorough as possible in detailing from their perspective the intended meaning and scope of any terms at issue. As noted, this project will utilize an environmental monitor at this site, which is a critical feature, particularly in light of the potential impacts to threatened and endangered species of grassland birds. To that end, I anticipate that the monitor selection process will confirm that the monitor will possess the appropriate educational and experience qualifications. In future proceedings, if parties have recommendations on such qualifications, it may be helpful for them to set those forth as appropriate in the proceeding. Now, one of the most important and critical issues, as noted today, relates to threatened and endangered species of grassland birds. There were disagreements over various potential impacts, most particularly with respect to row crops in terms of nesting and breeding potential and the risk of a direct take. Although in my view, Department of Environmental Conservation staff made some very cogent points in support of its position, and the protection of such species is critical. The order, as indicated, seeks to reach a necessary balance, and that balance is reflected in the certificate conditions referenced today regarding threatened and endangered species. I also note that the order also includes references that protective measures should be implemented during construction to avoid significant impacts to grassland nesting birds. I recognize that factual circumstances regarding threatened and endangered species in future matters may differ, and that conditions to protect such species may vary based on site relevant circumstances. Finally, I have one question for the examiners. Through these proceedings, I've been concerned about any potential financial burden on the local municipalities and landowners in the decommissioning and restoration process. For example, a key issue for solar projects is how solar panels will be disposed at the end of life of the facility. Now, I read the section on decommissioning and restoration in the order, as well as a section on cleanup and restoration, to indicate that the local municipalities and landowners will not share any of the financial decommissioning restoration burdens, and that burden is on the certificate holder. And I would like to ask the examiners if my reading is correct.
This is Judge Bergen, Mr. Alexander. Your understanding of that is correct. The certificate holder will be obtaining letters of credit. They will be held each by the town of Minden, one by the town of Minden, one by the town of Canajoharie, that would cover the cost of decommissioning. The towns would not bear the burden.
Thank you very much. Chair Rhodes, I have no further comments or questions.
Thank you, Mr. Alexander. Dr. Lewis-Michael, any comments or questions?
No comments or questions.
Thank you very much. Mr. Ravishir, any comments or questions?
No questions, thank you.
Thank you. Mr. Williams, any comments or questions?
Thank you. No comments or questions.
And Mr. Iacobucci, any comments or questions?
I do have a comment. I think part of the Clinton Road passageway is actually deemed a scenic byway to come from the New York State Thruway to access the, I think it's New York Route 20. And this project, I believe, is on both sides of that road and route. And I'm a local from here, and I just don't see it fitting into a scenic byway. And that's the only comment I have. Thank you.
Thank you very much. Judge Bergen or Judge McClymans, is there an observation that might help at this point, or should we proceed?
I'm not that familiar with the record on this. Judge Bergen, do you have some insight?
That particular issue was not actively disputed by the parties. That was involved in settlement. So
Understood.
To the extent the towns had concerns, it's my understanding they've been resolved.
Thank you very much. Understood. So that at least provides clarity on the record in front of us. And I'd like to proceed to call for a vote. With that, for the record, it's John Rhodes, Chair of the Board, and Chair of the Public Service Commission, and my vote is in favor of the recommendation to approve the application of Mohawk Solar LLC for a certificate of environmental compatibility and public need with conditions as just described. Mr. Alexander, how do you vote?
I also vote in favor.
Thank you very much. Dr. Lewis Michael, how do you vote?
In favor.
Thank you very much. Mr. Ravashir, how do you vote?
In favor.
Thank you very much. Mr. Williams, how do you vote?
In favor.
And Mr. Iacobucci, how do you vote?
In favor.
Thank you very much. The matter is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There's nothing further today.
Thank you. With that, we are adjourned, and happy Thanksgiving to all.